to establish coercive control based on numerous incidents of conduct that are enumerated in paragraph C, provided that they could reasonably be expected to cause the victim to believe their safety is threatened, which is consistent with what I understand to be the overall objective of a coercive control offense, which is to ensure that coercive and controlling behavior can be the subject of a charge and a conviction, regardless of whether other criminal offenses are also committed.
Thank you for that. Madam Chair, I guess the question we have to ask ourselves, I mean, and I'm glad Mr. Fortin raised this particular one, is do we as a committee, based on just this meeting today, not based on 332, not based on any of the witnesses that appeared before us at committee, are we going to make the conscious decision that in Canada from now on, if you threaten to kill yourself multiple times, that's a criminal offense? Because that's what we're doing here. And it could be that we would hear enough testimony from different groups that would lead us to the conclusion that, yes, there is a way that that could be incorporated. The problem is we, around this table, have not heard that. And I do think, by plain reading of this legislation, that that and some of the others are quite troubling, which is why the whole, and this is, again, not a reflection on our witnesses, but it's more directed to the government, the whole approach of introducing a bill that we haven't had. And I heard what Mr. Garrison said. Yes, we heard general testimony about 332, but we have not had the chance to specifically ask anyone about any of these specific provisions. For example, I would like to have witnesses here where we were able to ask them about each one of the itemized new non-criminal offenses that through this bill would now become criminal. So I guess that last one, Madam Chair, I'm just raising as a point to reiterate that at this point, unless we were going to unless there's people here that are going to enlighten us through more testimony on each one of these provisions, that I would have to vote against G2 and support the language that we've already considered and already had witness testimony on, which is 264.011 of 332. I think I did not hear witnesses say, you got that wrong. This bill is not going to be helpful. We heard some testimony that said there's models that itemize some things, but threatening to die by suicide was never suggested at this committee. So words matter. This is by the testimony of our witnesses here today, this is criminalizing non-criminal behavior in the context of coercive control. So obviously we have to be very careful about what gets added to that list. And this is just one that's been flagged. So I don't see how we could be ready to proceed with G2 on that basis alone.
Monsieur Fortin.
Merci, Madame la Présidente. Une autre question.
Thank you, Madam Chair. I have another question. While reading this, G2, while reading it, when it comes to paragraph 5, the last paragraph of G2, it says, for the purposes of this section and for greater certainty, a person's safety includes their psychological safety. Could you please explain what you mean by that? I've got several friends who suffer from anxiety. It seems that there are many people nowadays who are suffering from anxiety. I don't have any competence to analyse why and the harm as a result of suffering from anxiety. There's lots of different reasons behind this, and some people might consider that there's valid reasons, not valid reasons for suffering from anxiety. In any case, it's all very subjective. So when we say that we're addressing psychological safety of individuals here, does that mean that each partner would be responsible for the psychological safety of their partner? I imagine that's not what you driving at, but I haven't had time to really think this through. To repeat that once again, we're just reading this for the first time this morning. So how far do you want to go with this term of psychological safety? What does it cover, and what would the consequences be if a spouse or partner has psychological issues? And as we know, this is a pretty vague term, psychological safety, that really varies from one individual to another. We all have different limits. So I'd like to hear from you on that, please.
Yes, Mr. Garrison.
I believe Mr. Fortin has a sub-amendment on the floor, and we've strayed considerably far away from his sub-amendment. So I would suggest we need to deal with the sub-amendment. And then if people wish to continue to ask questions about G2, which don't appear to change their opinion of it, that's their prerogative. But we, I believe, still have the sub-amendment on the floor.
You're on the rush to reject my amendment.
So that's correct. We can't deal with the amendment. We cannot until we deal with the sub-amendment. So can I ask that we vote on the sub-amendment?
Puis-je avoir la parole?
Oui, Monsieur Fortin.
Could I please take the floor? Madam Chair, I very much understand my colleague, Mr. Garrison, that we've strayed quite a bit from my sub-amendment. I completely understand that. But the sub-amendment that I was proposing was saying that the offence could only be committed if there was reasonable cause. And I'm interested in everything else that flows from that, because there's a real cause for concern to see whether it's important to have reasonable cause or not, because we really need to understand the scope of this. So to come back to what I was saying on psychological safety, we're saying in the bill that it's going to be taken into account. And if this is very broad, and I have the impression it's very broad, then it seems that we're saying it's an offence only if it's committed without reasonable cause. So I do understand, Mr. Garrison, that you want us to vote on my sub-amendment, but first I'd like us to understand the scope, the full scope of this new bill, and is it wise or not to add in this guardrail and say only if this offence is committed without reasonable cause.
Merci beaucoup.
Thank you very much for that, Mr. Fortin. So I would like to invite us now to vote on the sub-amendment. The witness cannot answer my previous question before we vote. You still have another question? No, I put my question already, but I didn't get an answer. I was talking about the scope, in particular of Section 5, or Paragraph 5, where it said, for the purposes of this section and for greater certainty, a person's safety includes their psychological safety. I won't repeat everything I've already said, but I did want to hear from the witnesses from the Justice Department to explain what exactly this actually covers. What is the scope of this section, please?
Madame Levman.
Madam Levman, please go ahead.
Thank you, Chair. I would just point out that the term safety is already used in the criminal harassment and human trafficking offences and has been interpreted by appellate jurisprudence to include psychological safety. In that context, it has been interpreted to cover scenarios such as in the Sinclair case, 2020 Ontario Court of Appeal, that involved a person who was trafficking a young woman. He did not use violence against her. However, she was economically disadvantaged severely, had drug-related issues, and had no place to live. And so because of that, she felt that even though he didn't use violence or threaten violence, that she had to do what was being asked of her or else she would lose her place of her home where she lived and her ability to feed herself. So those are the types of scenarios that are captured by psychological safety. And I would also point out that Scotland, New South Wales, and Queensland, I believe, all three of them use the term harm and include psychological harm. So it is a term that has been used both in Canadian criminal law jurisprudence as well as in other jurisdictions whose models we are looking to when we craft these offenses. Thank you.
Je peux continuer, Madame la
Could I please continue, Madam Chair? And I don't want to waste the committee's time. I just want to really understand this. And I promise that I will be well behaved, but I do want to understand this. So so it says, engage in any other conduct, including conduct listed in any of the following subparagraphs, if, in all the circumstances, the conduct could reasonably be expected to cause the intimate partner to believe that the intimate partner's safety, the safety person known to them, is threatened. So reasonably be expected, and it refers to the context of the circumstances. And then under 5, it introduces this notion of also including psychological safety. So to come back to my example, if someone has a partner who suffers from anxiety, and I'm not criticizing this. I've got close loved ones who suffer from anxiety, and I have full respect for them. I don't want to criticize this at all. I just want to see how we could enforce our legislation here. For example, if my wife, now this isn't the case, but if my wife or spouse were to suffer from anxiety, and I have one of these conduct, for example, trying to control the way her manner of dress, or I threaten to commit suicide, and if she suffers from anxiety, then of course she's going to be even more concerned by this conduct because she already suffers from anxiety. And C says that we have to take that into account. It's part of the circumstances. Are we not further opening the door, further enlarging the cases where this would establish an offence? There's such and such a conduct, and given the circumstances, and given that your spouse suffers from anxiety, it was reasonable. You should have expected that. When you said that you wanted to commit suicide, you could reasonably have expected that that would have had an impact on her psychological safety. Now, I know you're not a psychologist, me neither, but we don't have any psychologists here. So what do you think about this? Are we not really opening wide the door when it comes to the zone to be covered? We're going to actually establish that a crime has been committed.
Ms. Levman?
So what you're pointing to is a potential prohibited conduct that would have to be looked at through the reasonableness lens, which is objective but specific to the circumstances of that particular incident that you've described. So the anxiety of the person would have to be taken into account when determining whether or not that conduct could reasonably be expected to cause the person to believe their safety is threatened. But in addition to that, you also have to prove intent to cause the person to believe their safety is threatened, or recklessness as to whether or not your conduct would cause that result. So there are multiple layers of different items that would need to be proven, including a pattern of conduct. So it couldn't be just once that, you suggested something that your partner who suffers from anxiety do or not do. So like I said before, we're dealing with ongoing conduct. No one incident in and of itself can ground a conviction for this offense, and everything has to be placed in the context of the relationship as a whole, has to be considered in the context of the relationship as a whole, which I believe is the provision that Mr. Garrison referred to earlier on proposed 264.01 sub 3, which provides another layer of protection to ensure that cases where there are two equal partners helping each other with problems are not caught by this offense. Thank you.
Merci, Madame Levman. Et
Thank you very much, Ms. Levman. And then to come back to everything that's been discussed, in Mr. Moore's example earlier, where a male or female partner says to their partner, we will not leave the house before you've taken your medication. Well, that there are these other levels that come into account, as you've said. But, for example, if you've got an individual who says to their partner, you know, you need to take your medication, otherwise